At BLM, we are keen to make sure you understand what to do if you are ever involved in a civil claim and to answer any questions you may have. Please watch the video which follows to find out more. We also provide further material for you to download and details will follow at the end of the video. If you have any questions, please do not hesitate to get in touch. Please watch our other videos in the What If series for further information on legal know-how for clinicians.
An adverse incident can affect a clinician in different ways, and a civil claim for compensation is one. But is there any overlap? Does a claim affect registration status? And can there be criminal sanctions?
We need to remember that a claim is completely separate to any disciplinary action. It is possible that the circumstances of the claim could potentially give rise to a referral to the GMC or the GDC, but it's by no means automatic.
A civil claim isn't a criminal matter either, and it doesn't result in a fine or a custodial sentence. It's a claim for financial compensation.
To succeed with a civil claim, a claimant, which is what we call the person bringing the claim, must prove that there has been a breach of duty and that this has caused injury or loss. What exactly does that mean?
A claimant must prove that no responsible body of GPs would consider the standard of care provided was reasonable. It's what we, as lawyers, refer to as the Bolam test. It's named after a case which went to court.
And it doesn't matter that two or more doctors, dentists or nurses take a different view. The claimant must prove that no responsible body of clinician would have done the same thing.
A claimant must also prove, in addition to breach of duty, that on the balance of probabilities he or she would have avoided the injuries but for the alleged breach of duty.
What happens at the start of a claim?
A patient may have already formally complained about the treatment or an incident, for example, to the practice manager or to the doctor or nurse themselves. If they then want to pursue a claimant is obliged to serve what we call a letter of claim.
This sets out the background to the claim, including who the defendants are, that's the person or the people the claim is brought against, and the claimant's allegations on breach of duty and causation.
What happens after a letter of claim has been served?
A defendant is given 4 months to investigate the allegations and respond.
Sometimes it can be the case that more time is needed. Generally it can be agreed between the claimant and the defendant and their respective solicitors.
The letter of response should respond to all of the claimant's allegations and confirm if any expert evidence is relied on.
What is the purpose of a letter of claim and letter of response?
The parties are expected to try to resolve the claim before court proceedings are issued, although it's not always possible. For example, it might become clear that there is an ongoing dispute on liability.
Once we've sent our letter of response, which will deal with all of the claimant's allegations, it's a really good opportunity for both parties to step back and take stock, and for the claimant to decide whether they really want to pursue the matter further.
How long does the claimant have to decide?
There's no strict deadline after a response has been served, but generally a claimant would have 3 years from the alleged negligent treatment to issue court proceedings.
What does court proceedings mean exactly?
Court proceedings are commenced when a claim form is issued at the courts. A claimant then has 4 months to formally serve the claim form, which means sending this to the defendant or their legal advisor.
As well as serving what we call the claim form, the claimant solicitors would also serve particulars of claim, which sets out all of the allegations, a schedule of loss and a medical report. Sometimes there may be 1 or 2, possibly 3 medical reports corroborating the injuries of the claimant. They all have to be served within 4 months of the issue of the claim form.
The particulars of claim set out the allegations on breach of duty and causation. Normally they mirror the allegations in the letter of claim, but sometimes the allegations can be expanded, reduced or amended in some way. The schedule of loss sets out the details of the claimant's financial losses or out-of-pocket expenses incurred as a result of the alleged negligence.
What happens after court proceedings have been served?
This is a really important deadline to be aware of. After the defendant has been served with these proceedings, there's a very strict 14 days to file a document known as acknowledgement of service or a defence. Usually in a case like this, you don't have enough information to put your defence in at this stage, but you absolutely must serve your acknowledgement of service within 14 days.
If an acknowledgement of service is filed, a defendant then has a further 14 days to serve a defence responding to the allegations in the particulars of claim. But even then, that usually isn't long enough, and further time for service of the defence is almost always required.
What happens if the claimant persists with the claim after the defence has been served?
The court will set down a timetable for various steps, including disclosure of relevant documents, exchange of witness statements, and exchange of expert evidence between the parties.
Disclosure of documents will certainly include the clinical records. Under the Data Protection Act, a clinician is obliged to provide the records within 40 days of a request. By the time solicitors are often instructed, those records have been provided anyway.
Any documents prepared when dealing with a patient complaint can also be disclosed, such as minutes of meetings or complaint letters or responses.
A really important point to mention here is that the clinician must never write anything in the records about the claim, for example, their thoughts or observations on the allegations. Otherwise, everything written in those records will be disclosed to the claimant.
It's also really important that a clinician doesn't retrospectively correct any errors, for example, typos or abbreviations, without clearly indicating in the records that they've been amended afterwards and why.
What about correspondence between a clinician and their legal advisors?
That would usually be privileged and wouldn't need to be shared with the other parties. Similarly, correspondence with our experts or barristers would be privileged.
How is a witness statement prepared, and what information does it include?
A draft witness statement is generally provided by the legal team, your solicitor. It follows what we call a proofing session. The solicitor will meet with the clinician. You go through all of the records and all of the background, and it really focuses on the factual issues. It doesn't give the doctor or the nurse an opportunity to comment on the expert issues in the claim. It's just sticking to the facts.
The witness statement will be in a specific format for the court, and it would need to be approved by a statement of truth before it's served. That's really important because if a clinician signs a statement of truth on a document knowing that it contains false information, it could amount to contempt of court.
Does a person have to give evidence in court if they have signed a witness statement?
That's possible, although it would be really early to say at this stage. A lot of cases like this don't reach trial and are resolved at some point beforehand.
Trials happen quite rarely. You need to be reassured that if it did get to that stage, then a clinician will be fully prepared by their solicitor and the barrister, so they can answer all questions anticipated. You'll be given full support.
Expert evidence was mentioned earlier. Will a claimant have expert evidence too?
The claimant will have normally instructed experts, and the reports obtained by each side will be simultaneously exchanged after witness statements have been exchanged.
Once the expert reports have been exchanged, the experts of the same discipline will meet up. Generally, it's by telephone these days. They'll stick to an agenda of questions and they'll be expected to discuss and narrow the issues. They then produce what we call a joint statement of all the areas that they agree on and all the areas they disagree on.
That really covers all of the procedural steps before trial, but what about settlement?
If the evidence suggests there could be difficulty in fully defending the claim, we could always consider making an offer to settle. Offers are often made without any admission of negligence and on a without prejudice basis, which means that they cannot be referred to in the court proceedings.
Settlement offers can be made at any time during the lifetime of the claim, at the early part or towards the later part, whenever the party feels comfortable in making that offer.
What if there was an agreement to settle, but the parties cannot agree on the level of damages?
A joint settlement meeting could be arranged.
Joint settlement meetings are sometimes abbreviated to JSMs. It's a form of alternative dispute resolution. It often involves a face-to-face meeting between the parties' legal teams, and normally the main purpose of that meeting is to reach an amicable settlement.
Would a clinician normally go to a joint settlement meeting?
No, not normally. The claimant would probably attend to give instructions to his or her legal team.
I have been to joint settlement meetings where the claimant has come along. Sometimes they've been part of the meeting, but often they're away in a separate room and they're not actually part of the financial discussions and settlement negotiations.
What would happen if no agreement is reached at the meeting?
The parties could still put forward further offers to settle the claim at this stage. The joint settlement meeting is not necessarily the last opportunity to settle.
If the parties really can't agree on a settlement and the claimant doesn't want to abandon the claim, then it will result in a trial. They do happen fairly rarely though, so it's nothing to be too concerned about at the outset. It can be a trial on liability, or it could be a trial on the quantum, or it could be a trial on both.
If we believe the claim is defensible but the claimant refuses to back down, a trial would be required to determine liability issues too, so that would be breach of duty and causation as well as quantum.
How long would all of this take?
Each case is different. Typically it can take about 1.5 years to 2 years from the date a claim is issued until it's actually dealt with by way of trial in the court. But as I say, each case is different.
But there are plenty of opportunities to resolve the case without requiring the court's involvement, such as a JSM. A trial is quite rare.
If it did ever reach a trial, then the judge would consider all of the written evidence, the statements, the expert reports, the joint statements of the experts in advance. They will have read all of the papers in advance of the trial starting.
At the trial, the barristers for each side will present their cases before cross-examining the lay witnesses, the experts, and any other witnesses that either party intends to rely on.
Each case is different. The complexity of the claim, the number of witnesses, particularly the number of experts involved, will determine how long the trial actually lasts. Sometimes it could be a couple of days, sometimes weeks, or even months. It just depends on the nature of the case.
At the end of a trial, the court would enter judgment. But what does that mean?
If the claimant succeeds at trial, judgment will be entered for the claimant. And then there would be a court order confirming that the claimant has been successful in the claim and dealing with the costs of the claim. If the claimant has not been successful, then there will be an order also confirming that.
Either way, there will be a public record of the court's decision, and that brings the risk of media attention. It's something to bear in mind when considering whether to settle a claim or take it to trial.
We hope you found our video informative. To download further material, please visit the link on the screen now or contact a member of the team. Thank you.